All right, why don't we, we'll call the meeting of the Aquifer Protection Commission to order at 7 o'clock on October 7th. Do we have an agenda for this, or? Okay, thanks. So we can name Derek for Jerry and Ned for Amy. Will act as voting members tonight. The approval of minutes of March 5th. Did you get a chance to look at those?
I saw them on email
Yeah.
when they first came out. I saw no problem with them.
I looked at them when I first read them, but
They seem fine.
yeah, all right, so we'll adopt those. Don't see any material changes, all right? So discussion and possible vote. Registration of David G. Marin, registrant for the F.A. Bartlett Tree Expert Company for the tree care company located on the property at 1250 Hot Meadow Street as an entity that has regulated activities occurring in the Simsbury Aquifer Protection Area.
Mr. Chairman, this is a little bit unusual in that initially, you may recall way back when the commission was given this responsibility and adopted the aquifer in that area, Bartlett was then leaving that particular building. They have since come back to the building. They have since decided to stay in the building in Simsbury, which is great. And they submitted the plan that they're required to submit. I talked to Howard this morning. The plan meets all the requirements of the aquifer protection area regulations, and our recommendation is that the registration simply be accepted by the commission.
Okay. No exceptions or anything we should note otherwise, all right?
It's just parking trucks there, isn't it, mostly?
Pretty much, that's right. They don't do a lot of maintenance there, but the idea is that the truck parking in that area, the garage in that area, requires that they're an entity that needs to be registered under the aquifer protection program. So that's why they've done a great job complying, and they've done everything we've asked them to do on that.
Okay, so let's just take both of these and then we'll vote on them. So the potential adoption of the modification of the zoning map to show the Terrafil Aquifer
Yeah,
Protection Area?
could I suggest to you that you just take the first one, and
Okay,
I'll tell you
so-
why.
All right,
Well, I'll move approval.
Second.
all in favor?
Aye.
Approved.
Thanks very much.
All right.
The second item is modification of the zoning map, which is in fact a public hearing item. Because it's a public hearing item, and I spoke with Howard again today on this, I think it's important that we notify the people that would be affected by the change in the map. The businesses, and you may see from his memo that there are 4 or 5 businesses in the area that would potentially be affected by it. What I suggested to Howard this morning, and he agreed, was that we notify those people prior to having this public hearing, and so that they get a chance to come in and talk about whether they are opposed or whether they agree or whether they understand the issue. I just think to have the hearing and to change the map without the owners of the property being notified is not a good thing. So that's what I suggested to him. So if you'd like, what we could do, what the commission could do, is schedule that hearing. I think November 21st, I think, is your second and perhaps only meeting in November. My suggestion is that date would be a good date. Should not take very long.
Okay. 21st, is that, that's the Thanksgiving week? No, a week before.
It's the week before, yeah.
Okay, all right, that's fine. All right, so let's do that. We don't need to vote on that?
Yeah,
Oh, you
please do. Set the
Okay.
date, yep.
So I need a motion.
So moved.
Second.
All in favor, say aye.
Aye.
That's it.
I did.
It's moved by Fisk, seconded by Pavich.
You said it's the 21st?
I think that's right, yeah.
Yeah.
Okay. I thought you said 22nd, I'm sorry.
And that's all I have for
All
aquifer
right, so
protection. Let's get-
discussion of next steps and future actions needed, that would be adjournment.
Move we adjourn.
Second, all in favor, say aye.
Aye.
All right, so that meeting is closed. And we will call to order the regularly scheduled meeting of the Simsbury Zoning Commission for October 7th at 7:05. Appointment of alternates, appoint Derek for Jerry Post and Ned for Amy Sauls. Approval of minutes of the September 16th regular meeting. I was not present, but I did read them, and
I was not present, so I can't.
Will, you were in charge, so,
They seem fine.
Yeah,
Alright.
I'm okay.
okay. So we'll move to adopt those minutes then. So the third item is consent items. First is application number 13-45 of Darcy Roy of National Sign Corp., agent for GC Simsbury LLC, owner for a sign permit for Berkshire Hathaway Home Services New England Properties on the property located at 920 Hot Meadow Street, map H09, block 227, lot 001, zone SC-1. These were reviewed by myself and Ed and the Design Review Board. They're basically just replacement signs, changing the name from Prudential to Berkshire Hathaway. So unless I hear any objections, we'll move to have those
The sign getting
approved.
any bigger, or?
No,
The same, almost, yeah, same exact size. All right, second item on the consent agenda is application number 13-46 of Edward Morrison, agent for Simsbury United Methodist Church, Methodist Episcopal Church Society, owner for a site plan amendment for a parking lot expansion on the property located at 799 Hot Meadow Street, map G10, block 202, lot 016, zone SC1.
This was really a minor change to their existing parking lot, simply to allow a few more spaces right next to the garage that's already there, not visible from the street. Essentially, very little grading is going to be involved. I think you've got the information in your packets in terms of, there's a minor amount of clearing that's there. There's perhaps a 1-foot retaining wall, 1 to
Is that all?
1.5-foot
Yeah, it
retaining
was,
wall.
I couldn't tell by the material how tall the wall was going to be.
Very short. You know, if it's 2 feet, I'd be surprised, but it's a very small change in grade. Staff really saw no,
Hiram, at one point, it is gonna be about 4 feet, but it's gonna be in that northeast corner,
yeah, as it comes to,
and it's gonna be behind the ABC house.
The setback from the new retaining wall to the property line is all within
yes.
setbacks, so. Did you get a chance to look at these? Anybody have any comments?
Just a question, so how many spaces are added? I saw the plan,
There are
but I
about-
wasn't
There are
sure.
about 7 spaces, I think.
About
11.
Is it 11?
spaces.
11.
Okay. It doesn't go any further than the existing parking lot in terms of its extent to the north. So the idea was to allow better turning, provide the adequate lane width, and provide the spaces that really would pretty naturally fit there, so.
We share our parking lot with a number of other community, the ABC house, the Maple Tree Cafe, and we do have some parking issues from time to time, so gaining 10 or 11 spots is greatly helpful.
I reviewed it, I thought it was fine. Dave, any questions?
No.
All right.
You're just cutting back into the hill further, is what it is.
Exactly.
Right.
Right.
Yep.
All right, so let's, I need motions for both of these consent agenda items.
Move we adopt the consent items.
Second.
All in favor, say aye.
Aye.
Both of those are approved. All right, item number 5, public hearing. Would you read the call? Ed, please.
Legal notice, Town of Simsbury Zoning Commission regular meeting. The Zoning Commission of the Town of Simsbury will hold a public hearing at a regular meeting to be held on Monday, October 7th, 2013, at 7 p.m. in the main meeting room at the Simsbury Town Offices, 933 Hot Meadow Street, Simsbury, Connecticut, on the following. Application 13-38 of Mark Lubetkin, agent for George Markatos, owner of 10 Mall Way, map G10, block 227, lot 001 ARR, for a text amendment to the town center regulations as follows. Freestanding signs are permitted in the SC1 frontage and are permitted in the SC2 or 3 frontages for properties on which there is a building to be protected, designated on the regulating plan, continued from September 16, 2013. At this hearing, all interested persons may appear and may be heard, and written communications will be received. Edward J. Pavich, Secretary.
Okay, do we have, are we doing the second as well, the public hearing, or not? Number 2?
The second item has been
No,
withdrawn.
there's nothing
Withdrawn.
else.
Okay, right, so that's the full call.
Yes.
All right,
Just to finish that thought, the third item, with regard to modifying the zoning map, again, we talked about that.
we spoke about that
earlier.
in the other meeting.
Second hearing for the 23rd.
Okay. All right, so the only public hearing we have is application 13-38 of Mark Lebeck. All right, please.
Yes, Charles Houlihan, Houlihan. I'm the attorney for the applicant in this, Mark Lubetkin. This is a continuation of a process that began in April of 2012, and the purpose of which is to erect a freestanding sign in front of the courtyard building. Mark Lubetkin operates the Redstone pubs that are in the back, and the idea is to erect a sign out front so that people can find the place easily, because there is a depth to this property that makes it difficult to see the signs that are over the entrance to it. It was originally begun as an application for a sign, and I have actually a history of the process that we've gone through. Through here. And at that time, Mr. Lubetkin went before the Design Review Board. And Design Review decided that it was unable to act because it was a freestanding sign was not allowed in that particular zone. When the regulating plan was adopted, the town opted for a very detailed, comprehensive one that is hard for a layperson to understand, but is very helpful for designers. And the escape valve was intended to be that you could seek alternative compliance if there was a problem. Under the regulating plan, however, alternative compliance does not apply to a sign. And so Mr. Lubetkin went before Design Review, and they said they could not pass on it because it violated the zone and they would not be allowed to do it. I would note that the Design Review said that that they found the application was generally consistent with the guidelines for community design, and they recommended approval. And there is no problem with the sign. The sign is, and I'll circulate this, it's a fairly simple sign. The Design Review was not opposed to the sign, but they found that they could not approve it since it was non-compliant for that zone. Similarly, I'd reference Code Studio that has reviewed this, and they were not unsympathetic to the idea of a freestanding sign, and they thought, and quote them, allowing a freestanding sign to support tenants in these key buildings may make good sense for the town. So after the application was rebuffed, there was a conference with the first selectman, the town attorney, Hiram was there, to try and figure out what was the next step to do and the most appropriate, the most direct way to handle it. And it was essentially decided at that meeting that a zone change made sense. To change this one particular piece of property, it's the only address on Mall Way. It is surrounded by asphalt, and the considerations that would prevent freestanding signs in some areas, the other cross-through streets, don't apply in this one because you don't have the anticipated sidewalk traffic that, like the retail you would have, for instance, on Wilcox Street. We came before planning, and we came before a Design Review again. And once again, we were rebuffed. And the idea being that the zone change seemed to be too drastic of a change. And people were worried about what will happen in 40 years. What if there's other design here, and are we really changing something? And our request that you needed to take care of the retail tenants today didn't carry the day. And so that application, even though it had been vetted before, was denied. The discussion centered on whether or not we should have a text amendment. And my concern was that on the front page of the center regulating plan, they have all these dark spots that indicate buildings to be protected. Most of them are in a zone, same zone that we're in. And I was concerned that our sign application would require us to rezone the entire town and the town map. I counted 53 buildings to be protected and thought that was an enormous burden to undertake to address the zoning in each and every one of those in order to have a text amendment. The zone change was thought to be more direct, more isolated, and tended a problem in this particular area rather than through the entire center zone. Code Studio was consulted on it, and they came up with an opinion the day before we showed up for design review and for the Planning Commission. And they said, well, they didn't like the idea of a zone change. But as I read earlier, they were not opposed to the idea of a freestanding sign, and they suggested instead a text amendment. And Hiram went back to them, asked them what a text amendment should look like. They drafted one. They say it'll apply to only 3 properties out of the 53 potential properties that there could be on this. And we have submitted the text amendment in the identical language proposed by Code Studio. And so we're here today to ask, after a year and a half odyssey, for the commission to adopt a text amendment and allow a freestanding sign to be erected here.
Can I ask a question, or?
Sure.
Yeah, can you explain why the 53 protected buildings was whittled down to 3? What was it about the other 50 that didn't? It's a question for you, Mr. Is it Houlihan?
Yes.
Thank you. And for you, Hiram.
Sure.
I don't know. I mean, I looked at the language, and in trying to figure out, well, if originally Code Studio said, well, it should be applied to a building to be protected. And my response was, well, there are 53 buildings to be protected on the map. And, but Emil and Hiram indicated that there may be 3 or 4 buildings only that it applied to.
Actually, it only applies to this amendment only applies to buildings in the SC3 zone, not the SC1 zone. So that eliminates 95% of them right there. SC1 zone is essentially the Hop Meadow Street. And so those are already covered by allowing to have freestanding signs. The only protected buildings that are in the SC3 zone, my total count is possibly 5, but generally 3. Courtyard building, little train station that's behind the bank, the Valley Home Hardware building. There may be one other, but that's it. It's a very small number because it's SC3.
So that is the difference. It's the SC1 versus SC3.
Correct, yeah.
Hiram, what is SC3?
SC3 is Mallway essentially, and that basically is that street frontage is what's used for that designation. So if you, and I don't know if you have a copy of the regulating plan in front of you, but the regulating plan, that's the sort of the picture is really the easiest way to do it. And the regulating plan basically shows that those protected buildings that are located in the SC3 zones are the only ones that are affected by this proposed change. So it's between 3 and 5, but it's a very small number.
What does it mean by the protected,
Historic, essentially.
Historic buildings.
so you can't change them?
No, it doesn't mean that. That's where alternative compliance would come in. That was if somebody wanted to change windows on the building, or they wanted to change the roof, or they wanted to change the doors. There could be alternative compliance with regard to things like roof pitch. The transparency is another thing that's called out in the code. So there could be minor changes to it.
But at Webster Bank, they're taking a third of the building off. Wouldn't that be unprotected?
Well, nothing's.
It's one of the dark ones.
Yeah, nothing's changed yet. I mean, there's no proposal to change anything there. That's basically Hop Meadow Street frontage. That fronts Hop Meadow Street.
The stuff they're talking about is taken off is the back.
That's correct.
That hasn't been,
It's
No, that's not even
it's
subject.
not protected. I mean, I think the discussion at that time when they come in is probably going to be whether that historically deserves protection or not. I've had numerous discussions with the design review board folks on it. We can get to that later, but chances
Yeah,
are
so-
not.
So let's stay on topic here. So the question before us is whether we should approve the text amendment as it relates to the SC3 zone, which would allow freestanding buildings for protected, do I have the right word?
Freestanding signs.
Freestanding signs for in the SC3 zone for buildings that are protected. Is that what's the word?
That's correct.
Yeah.
But can I just ask a question of the business owner? You want the freestanding sign marked so that when people go down Mall Way, they know where to go in and find your space, right? Because it's hidden, it's a little tucked into the court, and it's harder to see.
Absolutely.
So my question is, the building that you're in, how many other businesses are there on that street in different buildings than the one that you're in? Where I'm going with this is if you're walking down Mall Way or you're driving down Mall Way, how many other driveways could you pull into, or could people be confused about where your business is?
Dave Richmond has the building that's right on Hot Meadow.
Yeah.
His back entrance for the businesses in back of his building is a confusing location for people. They pull in there all the time thinking it's the Redstone Pub, and he's kind enough, he lets my customers park there. You can pull into the courtyard building, and the businesses that are there now is Jim Gallagher. There's a medical equipment representative in there. There's another small business in there. There's currently a hair salon that's leaving, that we're expanding into that space. There's a D.E. Jacobs, which is a design and review, and some vacant space where Odlum and some others work. And then there's a research group that does high-tech research, grant money for the federal government. And then the street behind us, it's not actually a street, it's our parking, but the town uses the street that goes through the Bank of America and Plan B, et cetera, and goes back behind Fitzgerald's.
Right.
And then there's the town parking, and then there's
Iron's on the end. Yeah, thank you.
This is the only Mall Way address, and the other buildings all front on Hot Meadow Street, so they're all SC1. And I've got a couple of photographs here of, the first one is kind of a close one if you're really inside the property. And the second one is really kind of across the street. And so you can see that there isn't really any visibility for the Redstone Pub, even though it has a sign out front. There's also the aspect that this building is back from the road a little bit. It's not as close to Mall Way as Dave Richmond's building is. And so looking down the street, you don't see anything right off. And so that, there's a visibility issue that concerns Mark. To try and draw traffic in there, people look and say they have trouble finding the place. And the sign that we've circulated before lists the other tenants as well. The hair salon was the only other retail establishment. The rest are professional services. And as I mentioned before, the design review didn't have any problems with that.
Right, and this is the permanent sign, though, that's on the...
No, this is a sign
That's
we're
the proposed
proposing
sign.
to
That's
put
the
up.
proposed sign. This is the sign that's out in front.
It's the same size as what's there now? The one that's
No,
Well, no, this-
there's no freestanding one out there now.
This is the one on Hot
That's what I'm
Meadow.
saying, this is to
freestanding.
replace the...
Not replaced. This will stay, right, on Hot Meadow? The
Yes.
Hot Meadow sign
Oh,
will
okay.
stay.
that's on Mr. Richmond's property, right?
Right.
No, it's on the state of Connecticut's property.
No, it isn't.
So is this a folding sign?
So this is
Is
what?
this an A-frame sign?
No, this is a straight up
Straight up sign.
sign out in front, directly in front of the
Very
the building.
similar. Yeah.
Let me just make one comment while you're doing that. This application at this time, just so the commission is clear about this, is for the text change. There's no sign application
Right.
right now. That's
Right.
that sign app.
Well, Hiram might have the floor, maybe it's the wrong time, but I'm interested in staff comments. In particular, there's a memo you put out today, I'm not sure everybody saw on the commission, and there's one that goes back to June, which maybe you forgot it. I wonder if you could just give us an overview of staff comments, is that all right? Because they may want to react to that, I don't know.
Whatever you want to finish.
There was a memo from today.
It's August, back in August, June.
Staff comments.
August 8th.
I don't know that I've seen the staff comments on this application.
Yeah, this was back in August when it came in. It was originally scheduled for.
If I said today, I'm sorry. You're right, it's August 8th.
I'm sorry, I don't believe that
Confused the dates.
I've seen those. The last I had seen was design code.
But there were staff comments in June, too. Was that June 10?
There
I don't
were.
have a copy, I just
And-
read it on,
And those comments were opposed to the zone change, thinking that the zone change was the greater burden and more drastic. I thought frankly that it was a more targeted and specific and limited approach. But we were rebuffed at both Design Review and Planning Commission. And since Code Studio had suggested the text amendment, we had asked them for what the text would look like, and they provided the language that we then incorporated in our application.
That's the current language you're
Yes. That language is identical to the recommendation of Code Studio.
And just so I understand the chronology here, since you were helpful in delineating it, when you made the original text text amendment change, when was that?
It was in, text amendment was after we appeared before Design Review, so it was in June.
June of,
June,
7/11/2013, text amendment.
yes. I'm sorry.
and what we're,
It was June 11th.
what we're considering tonight is the same exact text amendment that you made as it relates to the SC3 versus SC1 zone.
The first one was a zone change, and so
And when was that?
that we filed in May. We had our design review meetings on June 11th. We canceled the June 17 meeting before this commission because we were unsuccessful with the others. And we filed our text amendment then on July 11th.
Okay. All right, so let's, so we're in a public hearing, and so this is our opportunity to, any other questions for Mr. Houlihan while he's up there?
We have one other issue to talk about in terms of fee application.
I understand that.
And I don't know whether that's appropriate in the public hearing or later on.
Let us deal with the first, let's take this in two pieces, if you don't mind, all right?
The, and so, our history is that we've not had any difficulty with the sign itself, that it has been endorsed by different entities and consultants. Our problem has been finding the right pigeonhole in the regulating plan to get before the commission and something it could approve. And so we asked that the text amendment be adopted to allow some signage.
All right, thank you. Is there anyone in the audience that would like to speak to this issue? You need to come up where it's being recorded. Thank you. State your name.
David Richmond, 730 Hut Meadow Street. We own the property that actually has the only sign on Mall Way. We have a sign on Mall Way. part of our site plan. We also have a sign on Hot Meadow Street. So this sign will be about 10 feet from our sign on Mall Way. And I think it's an excellent, I'm in favor of the text change. I didn't know that was something that was holding it up. I know they've been working on this for 2 years, and it's a common thing. Find a business. A lot of people walk into our building looking for the Redstone Pub. And not to go into the history on the sign on Hot Meadow Street, because it goes back to the forefathers era, because we tried to have it removed, and then we realized that it was not on our property, and it's a very ugly sign, if you've seen it, next to what we've spent a lot of money painting and preparing constantly. There's that eyesore that sits there on the corner. So I think this will be a great addition to the property, and it will also help all the businesses in the building, which is an important thing that we need to do in this town to keep everybody from, keep the buildings full. So I'm in favor of the change, and I'm in favor of the sign, and maybe at a later date, you guys can visit the ugly sign on Hot Meadow Street that I gave up on 6 years ago, fighting City Hall, as they said. Any questions?
Thank you.
I have some questions. So you're talking about a sign that's in the corner that says the courtyard with an arrow, that one?
Yeah,
You're saying
that's
is
owned by the state of Connecticut. It's
But
been
that-
there since our forefathers, since the building was built. So if you're gonna look at this, maybe you could push that sign down or something. That's a package deal.
I feel almost compelled to note the irony of your complaint about that sign and the request for an amendment change that will allow a new sign to be made that maybe 100 years from now someone finds equally objectionable. And so, just to be clear, this is why these things are of great importance to all of us, because once played, they are there. They have a life of their own, and that's why zoning regulations and design guidelines and everything else are an integral part of trying to preserve our town. But I thank you very much for coming forward. Appreciate it. All right. Any other?
I can't find the proposed text amendment in this package.
It's actually in the call.
freestanding signs are permitted.
That's it, just this paragraph?
Yeah.
Where the freestanding signs are permitted.
I have copies of the application if you'd like it.
We have the application as well. It was in the packet. Anyone else from the audience wish to speak to the sign? All right, so I would look for a motion to close.
Actually, I have a question for Hiram, if you don't mind. I'm just looking at Lee's email to you about, actually, enter the bullet 3 here, located on an SC2 or SC3 frontage. Would it be better just to have it on the SC3 frontage?
It would that was Lee's suggestion, although the SC3 frontage would solve this particular applicant's problem, and that's one of the things I was going to address, actually.
And then in his bullet 4, it says, please note that the sign illustrated in the applicant rezoning package far exceeds the permitted freestanding sign. How do we address that?
And we don't have the application for the sign yet.
Right.
Yeah, that's the point I was making earlier, that this is actually not a sign application.
Okay, but they would have to come before us with a
Right.
sign app?
Yes.
Okay.
DRB, and they go back through DRB and.
Okay.
Hiram, did you discuss alternative signs? Because you mentioned it in this.
I did. The memo that I wrote back in August talks a little bit about that, and at the time, I had sent around copies of a variety of signs which would be projecting signs, which will be also possible, as well as building signs that could be attached directly to the building, which are also permitted under the current zone. These are all historic signs, and I think that you've probably all seen those in the package that I sent around before, but just let me quickly go over that memo just to frame those issues. In general, the zone or text change needs to be, because the commission's acting in a legislative capacity, this changes significant things that we obviously spend a lot of time in the downtown. The primary tenets of zoning law, when considering it, as Attorney Houlihan said, is a proposed zone change or text change is to grant the least amount of disruption to the regulation to accommodate what the commission considers to be the relief necessary for the specific situation. This particular application talks about change from to allow freestanding signs in the SC3 and SC2, in this case, zone, under unanimous recommendations to deny. Previously, the Design Review Board and the Planning Commission, the applicant withdrew the application. The applicant's submitting now the text change that you have in front of you. Very briefly, a few comments from staff. The current application, if approved, would allow the applicant to apply for a permit to place a freestanding sign on the site in accordance with the current sign regulations in effect at this time. It's important to note that any applicant for such a sign would still need to do the following. One, apply for the sign. Secondly, to ensure that the sign fit all the requirements as to location, that is not in the road right-of-way, which is an interesting question in this case, by the way. The sign size, ensure that the signage met all the requirements, including accommodation for other tenants in a multi-tenant building, which is the case in this case. To ensure that any proposed lighting was also in compliance with the regulations. Because this revision applies only to protected buildings, as was discussed earlier, the actual design of the sign should be in character that is subject to the building, character of the subject building and the site of the setting. And Design Review would address that as part of their sign review application process. The Commission, in this case, may wish to consider whether the desired signage requirements could be met with less disturbance to the existing regulations. It's a discussion we've had with the applicant many times. Basically, what it comes down to is the Commission has, in staff's view, two alternatives. The Commission could approve the submitted application as requested. It is recommended that the Commission make specific note of staff comments 1 through 5 above if you decide to do that. Secondly, the Commission could deny the submitted application if it felt that other solutions were present or could be made available which were less detrimental to the comprehensive plan. And then in this case, that means that the town center code and the regulations that are contained therein, but which still provide the Commission considers adequate signage for the applicant's business. I've also provided you copies of photos. The photos that you just got from Attorney Houlihan are a little blurry, but they're accurate. And I'm not saying that they're inaccurate, but staff has also provided, I think Howard went out last week and took some pictures that are pretty clear and show what the view looks like down Mall Way toward the building. There is an existing freestanding sign, I think as Mr. Richmond just pointed out, prior to getting to 10 Mall Way. One of the things that the Commission, and I suspect the applicant should consider, is putting another freestanding sign behind an existing freestanding sign, and whether that's going to remedy the visibility problem or not. Or whether a projecting sign from the existing building would in fact be more visible from Hop Meadow Street, which is, I believe, the stated intent. So those are questions of fact that you need to make a decision on. The pictures are what they are. And that's basically where staff is. We've made our comments. We're not in favor of any regulation change unless it can be shown that there really is a real need to do that. And I would leave it there unless you have any other questions.
But these photos that you gave us, I mean, a sign like this would be permissible
Yes.
on the building?
Correct. That could be done, assuming it met the proper size requirements and proper lighting.
Yeah.
A historical design such as those would be permitted tomorrow.
Harold, could you see a sign on the side of the building from Hot Meadow Street? Would it be large enough to be seen from Hot Meadow Street?
I think it would be large enough, depending upon what it said. If you tried to fit a lot of copy on there, it would probably be difficult to read. If you just simply had a large sign that said Redstone Pub, I would think, that you could see that. I might not be
It's
able
going
to.
to be cantilevered off the building.
Correct.
It would face Hot Meadow Street.
Right there.
It wouldn't face,
It would be parallel
and it would be
to,
attached to the building.
correct.
And it could be lit.
It could be lit, externally lit.
So it would be like off of this.
It would project out from that
Elevation
end of
right
the
here.
building, correct, yeah.
Right.
And that's another alternative.
Now, would that be permanent and therefore change if the tenant changed?
The copy on
I
the
want
sign
your
would
business to
change.
survive and do well.
Sure.
I'm just saying that sign would be permanent.
The sign would be permanent, the bracket would be permanent, the copy can change because, as you know, under the First Amendment, we don't have the right to regulate copy unless it's obscene. So that would remain in perpetuity, as the chairman said before.
Now, I will just say I have been to the site, and the building is set back a fair way from the street. So that is an issue relative to placing the freestanding sign closer to the street. But that's a consideration.
Can I make a final comment?
Yes.
You know, we're somewhat caught in a straitjacket of regulation here, which was not where we really wanted to be in designing the regulating plan for the center zone. The idea was to make the center zone vibrant, lively, have entertainment, have commerce down there, attract people down there. This spot that we're looking at is sitting in a sea of asphalt. It's a parking lot for CVS, the medical center on one side, Davis Parking is on one side. We've got the roadway and we've got the parking down there. We are the only lot on Mall Way. And we're trying to turn left and right and this way and that way to try and bring an element of commerce that has been lacking here. This can become a destination. It helps to develop the downtown. It is the beginning of a connection between the Fitzgerald Plaza and Wilcox Street and beyond. Before Redstone Pub was there, this was just a dark, empty area. We're trying. Pardon me?
It was a minefield.
We're trying to inject some life into this. The reason that the SC3 zone works in a place like Wilcox is you don't want freestanding signs when you have a sidewalk and you're expecting retail to walk up and down the sidewalk. You don't want your freestanding signs there. But no sidewalk traffic occurs here. This is an area that needs development. This is a link to try and lengthen the commercial area of downtown Simsbury. And we find ourselves having a difficult time making it known, making it shown and visible to the area coming around. We have customers that go into the wrong store because they can't find it. And so we find ourselves with the regulations that are designed to expand the district, to make it pedestrian friendly, to revive our downtown. We find our regulations are a hindrance here. And so that's why I thought the zone change made a lot of sense, because it was specific to the need of the particular area and the way it's constructed. That got shot down. Now we're trying a different approach. And I think the spirit of what we're trying to accomplish with the regulating plan is consistent with the application. Code Studio endorsed the application.
So we've been through this, so thank you. All right, you don't need to circle again. Any other questions or comments from the commission? We have closed the public hearing, correct?
Not yet.
No, we did.
Move we close the public hearing.
Second.
Oh, that's right. All in favor, say aye.
Aye.
You had one more question.
No.
No, you did 10 minutes ago.
Sorry.
That's all right. All right. So the public hearing is closed. This is the only public hearing item we have, so we could amend the agenda to act on this. We do want to address the second part of this, which is a request relative to the fees that have been paid. But let's take care of the actual text amendment.
Yes.
Go ahead, Ned.
Excuse me, but it's my understanding we're not talking about the sign.
Correct.
We're talking about the ability to place a
Place
sign.
the sign, correct.
And specifically, a freestanding sign.
Correct, and it will relate to not just this property, but any of, as Hiram has outlined, 4 or maybe 5 protected buildings that are in the SC3 zone. So once this text amendment is changed, if the owner of the railroad building wanted to put a freestanding sign in front of that along his frontage and it otherwise complied, they would not have to come in to get permission to place a sign other than to have it approved under the normal application for signs like we did for Berkshire Hathaway. So we're not just speaking, this is the text amendment we will we're considering tonight is not just for the Redstone Pub, it's for those handful of buildings that are similarly designated in this particular zone.
I have a question for Hiram. Hiram, is it your recommendation that we have all 3, SC1, 2, and 3, be included in this language, or would it be more narrow?
SC1 currently allows freestanding signs,
Okay.
which is essentially the hot metal frontage. What Code Studio said when they reviewed the application back in May, I think it was, or June, that it would not be a significant detriment to the regulations to include the SC2 and SC3 because the number of protected buildings specifically in those zones is relatively small. That's why they're both included there.
But you would want to include two, the property we're discussing tonight is an SC3, but you think it's a good idea to include in our considerations SC2 as well?
My sense, and I'm not speaking against the application, my sense is always to minimize the potential extent
That's
of
why
a
I'm asking
regulation
that.
change,
Right.
if possible. And if it can still serve the applicant and the commission decides to go that way, fine, but if you can minimize the potential spread of something that you may not know until later.
And there's further rationale to the extent that these protected buildings may not avail themselves appropriately to an attached-on sign as opposed to a freestanding. There's an element of that as it relates to design review, or the Code Studio.
We're looking at trying to get some consistency, and we already allow this in SC1, and we proposed SC3, and the only thing that's SC2 is Wilcox Street. It would think if we made the change for all of them, would be more consistent.
Well, to Mr. Houlihan's point, though, there really isn't any walkway, there's sidewalk and there are buildings along Wilcox Street, which is why it's designated differently than Mallway, because.
There's on one side. The other side is town
Correct.
property.
And all the way down Wilcox Street, there could, under the town center charrette process, be freestanding buildings, but there are setback suggestions or strong guidelines that they be similar on Wilcox, and that's why it was zoned that way.
The only building they seem to be pointing out here is what, going on this, the dark buildings or the protected buildings, is the old Town Hall Bank building, which is on the corner. The buildings behind it, the hardware store and what used to be the police station and things like that they're not on the protected list on Wilcox Street.
That's not Wilcox Street, that's
Station Street.
Station Street.
There's Wilcox Street. Okay,
Wilcox
Okay.
has the pizza and the,
all right. Sorry,
yeah.
never mind.
So,
Well, we should move the,
text amendment,
that we
yeah.
move that we accept the text amendment as presented, and then we can discuss.
As it pertains to SC3 only.
Correct.
We can modify it, but let's move it to start with.
Let's move it as it's on the agenda for the SC3 only. Someone second that? All right. So, any further discussion?
Now, we modified it to remove SC2.
Yes.
Correct.
Everybody agrees with that?
Everybody
Okay.
agrees that that's what we're voting. The motion is only for SC3.
Okay,
And just so that I'm
that's
clear,
fine.
sorry to be so dense, but if they were to, we're not talking about the specific sign, they still have to come back to us for the
Correct.
specific sign, okay.
And as far as just how the record reflects this, the way it's currently worded, we would leave SC1 in there because they currently can.
No.
Because it now says freestanding signs are permitted in the SC1 frontage, and that's a correct statement as I understand it.
That is
What are you reading from?
Top of that.
Under re,
Yeah, why is
So you'd
that?
leave
That's
that because
redundant.
it's correct.
It's correct, but it should be redundant. Is it not?
You would just take out the reference to SC2, as I understand the way it's currently drafted. Change the drafting, but right now it's, makes reference to what's already allowed, which SC1 should be included in.
Okay, I agree with you, Will. So the only change to the text amendment, which is in italics in the call, was it in the call?
This is
Yeah.
what I used to.
Yeah, so we would, so the motion that's on the table is to read as follows. Somebody get this right. Freestanding signs are permitted in the SC1 frontage and are permitted in the SC3 frontages for properties in which there is a building to be protected designated on the regulating plan. And we would strike the
SC3
words
frontage.
SC2.
SC2.
Yeah.
All right? Any other discussion amongst the commissioners? So all those in favor, say aye.
Aye.
All those opposed? So the text amendment is passed as modified. We would be glad to, at this point, hear any comments you have relative to the fees, Mr. Blaine.
We wrote a letter to the first selectman dated August 8th, in which we asked for a partial waiver of fees. Because we've been the first applicant sort of out of the gate to walk through this process. It has taken a great deal of time and expense and still has yet another part to come. And in that letter, we noted that there have been expenses of $1,250 incurred. I don't know if you have a copy of that letter for you. First for the sign permit for $160, then for the zone change for $690. Text amendment, new fees are $290. There's a state fee of $60, public hearing fee today of $50, for a total of $1,250. We were trying to find an efficient and appropriate way to get from here to there, to lighten up the area and to make sure that that we can encourage retail traffic into the bar. And we tried to use and implement all of the informal methods that are available to us, meeting with town staff, meeting with first selectmen, discussing it with the town attorney, trying to find the most targeted, least disruptive way to go through that process. And there's been some resistance to tinkering with the regulating plan at all, because so much effort went into it in the first place that, for instance, after we had met and discussed the idea of a zone change amendment, we didn't hear from Code Studio, for instance, until the day before we went to planning and to design review in June. And then we got the suggestion the day before, well, maybe it should be a text amendment. So it's been difficult identifying the process to get to. And each time we get to a step, we're surprised, or we don't quite get there. I didn't know about the August staff notes, and shame on me for not coming down and looking at it, but I thought that I had all of the materials and had seen the Code Studio recommendation, and that's what we used. And so it's been, on the applicant's side, it's felt a little bit like whack-a-mole. And
Like what?
whack-a-mole, where you hit a mole and the mole pop up somewhere else. Each time we go along, we...
So what's your theory upon which you are entitled to a waiver or refund?
Well, I think the fees that have been incurred in this are a result of trying a new system. A system that I originally thought when it was adopted that the alternative compliance would speak directly to these kind of issues, and didn't realize that, signs have been excluded from that. And as a result, we've gone in three different directions to try and accomplish, I think, something that's consistent with the overall plan. The system has been cumbersome, it's been burdensome, and we think that there should be some relief in here. Certainly, the zone change aspect that we thought had been green-lighted and had support, fell out from under us, and that, resulted in, half year's worth of delay and additional costs. So finding the way through under these circumstances has been difficult, and it was taken to the Board of Selectmen. The Board of Selectmen then referred it to the Zoning Commission to decide whether it's appropriate in this circumstance. And we would ask for some relief, not all, but some.
How much was the fee relative to specifically the zoning?
That was $690.
Seems to me if it didn't even come to a vote in zoning, they hardly completed the zoning application, and that I would think we could waive and say that's the biggest piece of it. That was never progressed beyond to a voting.
I see both sides of this very clearly, as I'm entitled to, but I do understand that did not bear fruit. But there was a fair amount of work that had to be done on the part of the staff and the consultants, including our town attorney and the like. So, I recognize. Do some have the list of the actual fees that were paid?
I got this, which is in the package, I don't know.
Yeah, I was too lazy to dig for it.
It's in a Houlihan letter. Another one? Now,
Are the invoices attached here? Did I miss that?
Is that that you sent? The staff meeting? Hang on.
Oh, it is?
The,
Can you point me to that, Hiram? Just,
Right after Chip's letter in the package, I'm sorry, Attorney Julian's letter in the package, where his number is 1250, I think, he said. What I asked our office administrator to do was go through the files, look at all the checks that we had, and she's listed the check numbers and the amounts there. We come up with 1140, just for a small difference, obviously, but that's our calculation. It does still include the 690 that was just discussed. Includes 160 for the sign permit, 180 for the text amendment, and the state fees and public hearing charges for the text amendment are 110.
you have 290 for the text amendment.
290 plus the additional fees. I think we paid.
Well, if you want to call Mr. Malloy and ask him if he'd give back the state fee, we could work on that.
When we were before the planning commission, there was some general discussion about whether or not there should be some refund.
Some what?
Some refund for the zoning application. They didn't vote on it, they didn't act on it, but there was
And these are,
To be fair, yeah, neither the Board of Selectmen nor the Planning Commission is actually making the decision, so. It's huh?
decision, maybe the Board of Finance.
So they won't like whatever we do.
But these are all purely fees, and there's no other services in these numbers?
No, these are what-
Attorney's fees or otherwise?
attorney's fees would be,
And I'm not speaking about you specifically, I'm just
No,
saying.
these are what we
pure
pay the-
fees to the town.
that's right. These are, I believe these are the checks that Mark made out for various expenses.
Hiram, do you have any additional information on this topic?
Just that our calculation was slightly different. As
How
staff
many
per-
acres?
I'm sorry?
It's 180 on one and 90 on the
Yeah.
other.
As a staff person, I would not recommend the fees return. I certainly understand if the commission decides to do that, that's understandable. Tremendous amount of work did go into it, number of meetings went into it, town attorney was involved, first selectman was involved, number of commissions were involved, DRB, planning, and so on. So there's been a significant amount of prep time for every single one of these. So based upon whatever the commission decides to recommend back to the Board of Selectmen, we certainly would go along with it, but we don't.
So yeah, just to be clear, we would recommend and then the Board of Selectmen would vote on it?
Correct, we don't have the ability to waive the fees, that's why the Board of
So
Selectmen.
we make a recommendation and they get to vote? That's not a smile, man.
Correct answer.
Excuse me, Hiram, but before the horse is finally back in the barn and the applicant does get a sign, are there any more fees?
They would need to make a sign application.
So there'll be another sign permit application.
If the commission decides to accept it, they could submit an application and request the fee be waived at that time. We'd go back to the same.
How much would that fee be?
160 the last time.
$160.
How is that different from the signed permit? Is that,
Same thing. What happened previously, it perhaps wasn't explained clearly, is that there was an application to modify the sign that's at the corner of Hop Meadow Street, to rehabilitate that sign. That's still not been done, and that was almost a year ago. I think that's the sign that Mr. Richmond referred to as he wanted to get rid of. That's not been modified. What the design review board said at the time is that they didn't have any problem with rehabilitating that sign, go ahead and do it. The second part of that same application, however, was for the freestanding sign on 10 Mall Way, and that's what they did not act on because it wasn't in the regulations. So that was part of that fee there.
I'd just be cautious in setting any type of precedent
Well,
in
for sure.
returning fees. You know, I mean, you apply, it doesn't mean that you're definitely going to be approved. I mean, I applied to many colleges and spent hundreds of dollars and didn't get into a lot of them, but I would just be cautious about setting a precedent.
But I think if it didn't reach us for a vote, somewhere or other the process stalled and didn't work. And in this case, we have a new set of regs, and it seems to me that we're stuck in mud, that people can't get things done on a timely basis. If he depended on that sign to get his business going, he'd be a year now downstream hurting for business. And that's not what makes a business-friendly community. And I'm kind of worried about that sign.
It seems to me, though, that if the authority to do this rests with the Board of Selectmen, that they should be able to make a decision on their own without our input. It's not, I mean, we've never done anything like this, we've never discussed this.
Well, but the work was done in front of us, Ed, so they're asking for our advice and consent, so. I'm gonna make a suggestion and see what the commission thinks about it. I would suggest we refund half of the zone change fee and agree that no additional application fee will be necessary for the sign when it comes in.
I like that. I was thinking the
I'll
same.
second that.
All right, all in favor of that?
Aye.
All right, so this is a recommendation from the zoning, Opposed? Okay.
Let the record show.
Opposed.
All right, so let's be careful. So the vote is
4 to 2.
4 to 2. The recommendation, that's a recommendation from the zoning commission to the Board of Selectmen. Let them act. That's our recommendation. All right? Thank you. All right. This is the point of the meeting where I've lost my agenda. Okay, so we're skipping,
Next page.
yeah. All right, so we moved on to discussion of possible action on any agenda item, including application number 13-30 of Matt Whitmer, a Phase Zero design agent for GPF Drake Hill LLC owner, for site plan amendment on the property located at 720 Hop Meadow Street, zone SC1, which we now know that freestanding signs are permitted. So this is for the Cannon Building, okay.
That is correct.
Okay.
The other side, Mall Way.
Yeah.
Yeah, it's right there. Yeah, hi, good evening. For the record, my name is Matt Whitmer from Phase Zero Design. Stephen Walker, the owner of the property, is here as well tonight. And this application does have to do with the building known as a Cannon Building. We are proposing an addition on this building, in fact, that faces basically the Fitzgerald's, the Drake Hill Mall area, facing that parking lot. This area that we're looking to add on to is actually a former plaza, if you will, that's in somewhat disrepair right now. Back when this was a residential structure, there was probably a porch or some element on the side of this building. What remains now is a small brick wall and a plaza, which is in somewhat disrepair. The idea is to take the footprint of this building and put on a single-story addition that you see here. This is actually Cannon building itself. This is the addition at this end. The idea of this building is to be a porch-like structure, very complementary to the residential building that was there in the time, so that if in fact you can imagine an enclosed porch being added on, it'd certainly be very reminiscent of what we have here. The architectural features and the design of it are very much in keeping with what's been done on the north end of the building, which is actually a covered area where there's a drop-off for handicap parking. And that's actually, we take the same band, the same frieze, the same fascia, and apply that down here at this end. So it really tends to balance the building, create a nice bookend, if you will. We have looked as well on some landscaping. We do have a height change, so we have a couple of steps that brings us up to this space. We do have a crosswalk and a ramp that will bring you up for handicap accessibility. We do have these plants that are all going to be featured here. And we do have a planting plan that was created by CR3 that shows how these plants are going to be put around. We're actually much of the southern area of the building along Hot Meadow Street is going to be replanted, as well as the ramp area and the area around the steps and the sidewalk, all to really make a nice green space, kind of much more of a park with some plantings than certainly what's there now. And the idea here is to create this addition for a future business. This would actually become leasable space that would be accessed from this area off of the Drake Hill Mall parking lot. And there are a couple of handicap spaces there as well to allow patrons to enter. I have some photos of the existing building here as well, which is included in your handout. And I will add that this project did go through design review. Certainly was approved. One of the items that they did mention was doing something with the existing concrete and brick plinths, if you will, that are on either side of the steps, if we could reuse them. So we are looking to reuse them in this area to kind of focus on the stairs. That's something that's not in your handout, but I did want to show you that we're certainly looking at that and reacting to that. We think that's a good idea. If we can reuse those existing components, we'd certainly like to do that, and certainly like to have them on either side of the walk and the entrance stairs.
And again, what's the purpose of the additional space?
It is going to be for a business, future business that will front Drake Hill. So we'll utilize that. Right now, or I guess I should say in the past, there was a blood draw area in that building, a very small one that fronted on Drake Hill. That's actually moved above CVS. So it's vacated this space, and the desire now is to increase the amount of leasable area.
Including the porch will all be, can you just, I was just unclear on what space will be retail? Just the new building, just the new addition?
This will be retail as well as this area here will be
Excuse me.
retail. Currently, the space here now was split between the blood draw space as well as the doctor's waiting room. And the doctor's waiting room is actually going to be reduced in size, and that's going to become part of the business as well. I can show you probably on this plan shows it the best. So this is the existing. This was the blood draw area. This was the plaza right here.
Yeah.
And then this was the doctor's office. So this is the addition that's going on here for this porch area, the former blood draw area, and the existing doctor's offices will become
So as you come
retail.
in from the Fitzgerald side, will you be immediately in that business, that retail business?
That's correct.
And you walk through it to the doctor's office?
No, you will not. The doctor's office is still accessible, both through the front door here, and their handicap entrance is on the north end.
Okay.
We talked about.
So the building is already ADA compliant?
It is on the north end, and you can traverse the building that way, yes, that's correct.
So how many feet are you adding to the front of the building?
We're adding a total of, which doesn't say it on that one. I think it's about 18 feet that the building is being added onto, 16 feet.
What about,
But is that currently an access point into the building?
It is currently an access point into the
So
building.
what
yes.
happens to that traffic? You just redirect it to the front? Is that what you're saying?
Oh, no, I'm sorry. That was an access point only to the blood draw station.
Oh, okay.
Yes.
One point it was a flower shop,
It
as
might
I
have,
recall, and then there was
I
the
don't-
blood draw people there.
don't even recall that, but yeah.
I mean, what kind of retail do you anticipate there? Is it, I mean, what would the target retail be?
Well, I mean, I could-
Any ideas, Mr. Walker?
Yeah, we do, we thought it could be a spa for one idea. It's such a beautiful building. I guess that's the top use.
So, I mean, when we say retail,
Yes, we
not
don't see
talking
it
about
being a
Mr.
we don't
Amazing.
see it being a restaurant or, a Starbucks, that sort of
That's
thing.
what I mean, what
We
you-
kind of
yeah.
see it more, it could be a really high-end attorney's office, it could be a spa, a hair salon, that sort of use in there. Because there is the medical component to that, so you have to be careful with that, what you have going on over there. Could be an architectural firm, but Matt does have a beautiful office.
Is there any vacancy in the building now?
No, it's 100% occupied.
Yeah, these two tenants are leaving.
Yeah.
It just seems like a lot of, when I'm looking at the ramp, and it just seems like a lot of architecture for, so what's the total square footage that you're gonna be adding? Is it?
It's probably, what do we say, about 1,100 square feet, I think, in
Yeah,
that
1,000,
range.
1,200.
But then, of course, you're complementing that with spaces that are not used right now, the blood draw and the doctor's office. I think you're coming up to a suite with about maybe 2,200, somewhere in that range, is what we're
I'm just
looking
talking
at.
about the addition itself, but
Yeah.
yeah, so 1,100, 1,200 feet.
It's certainly a nice opportunity. It kind of completes the building. I think what it does too is it creates a lot more activity along, in the Drake Hill on the mall side. It seems to be pretty appropriate for, for what you have
Can you show the
right
front
now.
elevation again? I wanna see how that ramping affects the front of the building.
We've got, for the size of the addition, Matt, maybe, correct me if I'm wrong, 14 feet by basically 40 feet, which comes to 560 by
Yeah, it's a lot smaller than that.
So those are the steps that are walking up from the side, and the ramp actually goes straight back or to the front?
Straight
forward.
The ramp actually goes straight forward, very much like what was done at the Starbucks right across the street. We have that ramp coming out. And just like what was done in that area, we're choosing to do some greenery around that.
What
That'll be very
materials?
around.
What materials for the ramp?
That's a metal handrail on that ramp, a decorative handrail, very similar to what you have now. And then it's going to be a concrete ramp, and it's going to be covered with the, surrounded by the plantings.
What are we doing to address the parking for the additional square footage? The
think
parking
that-
seems to be on the other guy's property.
Yeah, I think you're covered in the town plan for the parking. There's plenty of parking around there for, the lot
Behind the building.
that's there, yeah.
Is that shared parking? Or in that particular complex?
Well, there are a number of uses that, and certainly the owner could speak to this better than I, but there are a number of uses, obviously, that share that parking lot. Some, I would suspect, that tend to use the Cannon Building would park over that end, as opposed to Fitzgerald's or Peaberry's or something. But to be honest with you, this is one of the things I was going to talk about. I haven't done that analysis, to be honest with you.
It seemed to me that we lost parking when they redid the parking lot at the grocery store.
I'm not sure about that. I think that is the same parking that was previously there.
Now, they got all those islands in there.
Yeah, but they expanded it more towards the church on the corner, Ned.
Yeah, I think it was a wash
Yeah,
on that.
we went through all of that, because they added the bank building and everything else. It was all covered. Any other questions for Mr. Whitmer? All right, thank you. Hiram, do you have comments or questions?
What I'd just like to say on this one, and I have to apologize both to the applicant and to the commission. I did not expect to be out of the office last week at all, but I was the whole week, and haven't had a chance to put into proper context for you the design review board minutes, the discussion that was held there, and my own comments. I just haven't had time to do that. I certainly could do that in the next couple of days, but I haven't had time to do that because it's a protected building, which we've all discussed a little earlier this evening. We know that it's important to protect, and I'd like the opportunity to put that staff report together for you before you actually vote on it. I don't know that it's necessary that the applicant return, that's up to them, but I would just ask for that time to do that for you.
And what did the DRB say? They approved it or recommended it?
They recommended, their finding was that it was essentially consistent with the guidelines of community design, yes.
I read something that they voted to not approve it because of the way the handicap ramp sticks out in front.
There was lots of discussion about that, Dave, but what happened was, I think it was a split vote, that the number of people that recommended approval prevailed, but there was lots of discussion about that prior to the vote. That's my recollection of that meeting.
I remember something in the packet that said that they voted to turn it down. Did I misread that?
Yeah, that's that too, now that you mention it. Yeah.
I don't
What-
remember reading it that way, but
What kind of timing is this? I mean, the next meeting we've got is the end of November?
no, it's 21st.
21st,
Yeah,
oh,
just a
okay.
couple of weeks.
Yeah. So I think we should take advantage of Hiram's suggestion and have the staff comments and the design review board minutes, which we don't have, so.
Just point of record, does this need to be extended then? Are we, so I think we had submitted this a bit ago, have we not?
Yeah, would you have a problem extending it?
I don't know, I could talk to the, my client about that. So we would have to extend this another
2 weeks.
2 weeks.
It's there.
Probably be good to know that before they decide to do that. Again, my apologies.
Can I take a sidebar or do?
Sure.
I'm comfortable.
Okay, no, sorry, all right, thank you.
I think it would be
Record.
best for everybody not to be pressured into making a decision tonight.
That's
All right?
fine. I mean, obviously, I don't know what the issue is, but the design review did approve it. I mean, certainly there was lengthy discussion, so if there's something in the packet that says that they did not, that in fact is incorrect, so.
Well, unfortunately, Hiram
Give Hiram
was,
enough time to.
yeah, was
Thank you very much. And again, I apologize.
indisposed last week.
I'll try not to do that again.
For a whole host of reasons.
I was felt that something had been chopped off at some point in time when that building went from a residence to a business, and that there probably was some sort of a potting or some kind of something there that would have, for growing plants or a sunroom or something on the south side of that building.
And one of the
It
comments.
seems like it was chopped off.
I think one of the comments that perhaps even Matt made earlier was that historically, this would have been the type of house where there would have been a summer awning on
Yeah.
the south side. And perhaps that was what was there, and I don't have any historical pictures to prove that, but that certainly would be a logical thing, yeah, absolutely.
All right, thank you for
Thank you.
indulging us with that. We appreciate it. Okay, next up, application 1344 of Chris Millard. Is that right? Of Phase Zero Design, agent for GC Simsbury LLC, owner for site plan amendment on the property located at 920 Hot Meadow Street, zone SC1. All right.
All right, so I'm not Chris Millard, but I'm going to stand in for him and do my best. Again, I'm Matt Whitmer for the record, and this is actually a proposal at the Simsbury Shops to expand Subway. Subway is actually one of the best performing locations within the region. So one of the things that they're looking to do is redo the interior of the store and get a couple of extra square feet for them, increasing their footprint. One thing I will tell you is you see on this on the west elevation right now, the awnings and window system for the former Metro B's is shown here. That's for informational purposes only. That's already been voted on and approved by this group. So really what we're looking at is, and there's a line between here, it's everything to the south of this line that we're showing here, which is a new entrance for Subway, a new awning. And most importantly, the old entrance is being infilled. Right now you have an overhang here for the old entrance, and then you also have this porch in the back here with a metal railing, and it doesn't really work that effectively. So we're looking to actually infill these two areas that you can see here. I believe the landscaping and the site work was already previously approved. but certainly the awning, the window systems, and the additional square footage is what we're looking at coming before you tonight to present.
Was that landscaping that's directly in front of the new entrance, was that there when we approved it?
It was a lot closer to the building. I don't recall the courtyard being quite as deep with the ability to have a door in the front. Our understanding was that the window on the, I'll call it the right side of that diagram, was going to remain the same. That was part of the original application.
This
Yes.
window here?
Yes.
Yes, that you're absolutely correct.
And so there was no door on that front, and the landscaping was actually tucked right up against, well,
I didn't
very
think the
closely.
landscaping came out that far
It
in
didn't.
what we approved. I mean, I don't have a problem putting the door in there, but
I can say this, that there was a discussion, if you recall, about the steps dumping right into the parking lot. And I think what the applicant's done, and I think it's a good thing, in my opinion, is that they brought basically the steps down and then basically protected it with this curve here so that there's a landing area.
so they did that before.
That's my understanding, my recollection, correct? Yeah.
That looks more walkable, safe.
We approved something for the Metro Beach site, okay? But was anything done?
Not at this time, not yet.
Okay, so now we're looking to make another change to the other side of the building,
That is correct.
okay? But it's not gonna reflect the changes that we approved for the left side of the building.
They're still approved, they just are you gonna do the work on both sides at the same time or not?
We're gonna start on the Metro Bis side in the next couple of weeks. Windows have been ordered. And the subway, we hope to start in early spring.
Okay.
Is it possible to do them so that they look alike?
Well, actually, it's interesting you bring that up. I mean, this is something that was vetted a significant amount with design review, and they did, in fact, approve the design that's before you tonight. And the idea was to create some autonomy between the two different spaces and be able to separate that, but also bring a lot of what's there as far as the window systems from the rest of the building into this, so that you didn't have an end gable, if you will, that had two identical buildings, two identical facades. Right now, what's happening is it creates confusion.
Right now, it's two identical facades.
Right, this is it right now. Exactly. And, other than these two signs, you really don't know that there are two tenants there. Their entrances are on the sides, not in the front. Doesn't bode well for the tenants for use.
I think it brings up a good point, though. I don't know if we need to belabor it, but the landscaping that we approved as part of the other application is not consistent with this, and I don't know if we can actually approve this without making a change to the previous. I'm not sure.
Yeah, I do think, I mean, my recommendation is, I think it's the same thing we looked at.
Okay,
To be
okay.
honest with you.
All right, any other questions? All right, so we can take action on this, and staff's recommendation is positive on this?
Yes, it is.
Okay.
Yep.
So I'm looking for a motion on this.
Move we accept.
All right, so moved by Ed, seconded by Will Fisk. All in favor, say aye.
Aye.
Opposed? None? All right.
Thank you.
All right, we have two other informal presentations we want to try to do tonight. It's 8:25, so we'd like to informally ask you to be informal and brief.
Correct, Mr. Chairman. Technically, what we, commission needs to do is amend its agenda to add two informal presentations to its agenda for this evening. One would be an educational presentation on medical marijuana, use of medical marijuana. And the second would be an informal presentation for a potential development at Dorset Crossing for the apartment property at Dorset Crossing called East Point.
Okay, who asked first?
I do not recall.
All right, we'll go with the medical marijuana first.
We have to make a motion.
Yes.
I move.
Oh, to amend the agenda?
Amend the agenda.
All in favor, say aye.
Aye.
Thank you.
Under discussion, it's now 3-0 Red Sox in the fifth.
I made the motion, who seconded it? Ed or Will? Ed did, yeah.
So this is just informational. We can't act on anything here, so it doesn't have to be noticed to the public that we're talking about it?
Hot smokers or the other one?
We get the patch here, so. It might not be public, but it'll be in the internet
Yeah.
tomorrow morning.
That's right.
Okay. We don't have the connector.
I'm gonna walk into the Redstone today and tell Mark he should have a sign out there.
He's closed on Monday.
Oh, he is.
Tuesday. Yeah, because every time we make this meeting, we can't go there.
Right. Hey, how are you? Oh my gosh, how's it going? Nice to see you.
Sorry, our printer kind of had an issue and we needed to get here on time, or we would have had copies for everybody. Thanks.
Introduce yourself, please.
My name is Eileen Konieczny. I'm an oncology nurse. I've been an oncology nurse for over 20 years. I was instrumental in getting the legislation passed here in Connecticut. I worked as executive director of the Connecticut Cannabis Business Alliance, which was a trade association formed for the industry by the industry coming into Connecticut. I am also a board member of the American Cannabis Nurses Association. I also am the owner of a patient advocacy organization called Olives Branch, which is basically an organization that I formed to educate patients and healthcare providers about the medical benefits of what medical cannabis can do. So that's who I am. Let's see.
You're not with Normal then?
I'm not.
Okay.
AP. Sorry. There it is. All right, okay.
Or you can just click.
I tried to do that. Okay, so this is really nice. The DCP, and I don't work for the Department of Consumer Protection, but I know this, I know this legislation really, really well. And this is on their website to help all the different communities get understanding of what this legislation really is about. So I'm going to talk about the law that has been put through, the protections for the communities that have been put into place, the application process, and then I can answer any questions that you all have, okay? So the act concerning the palliative use of marijuana, that was signed into law on May 31st of 2012. The governor signed that. There was a temporary registration program started October of 2012. At that time, when patients could sign up to the program, and with a recommendation from their physician, it kind of gave them a get out of jail for free card is really what it really was. It allowed them to use marijuana if they had access to it, and it provided them with not having to go to jail if they got caught with it. They were writing the rules and regulations all the way up until there was a public hearing in April. They went back and they formulated all of that. And the August 27th, it went out of the Regulatory Review Committee, approved, and then the application processes were just started. September 13th is really around that when they came out, okay? But what the program has done is it enables seriously ill patients to use marijuana as an alternative treatment to basic pharmaceuticals, and it also provided the regulations also provide safety for the people in the government and physicians and caregivers from any kind of civil penalties. The law was designed to prevent misuse and diversion, so it's a limited group of debilitating medical conditions. There's 12 of them. The physicians are the gatekeepers, and there's all kinds of checks and balances that the physicians have to go to, so not every physician can write a recommendation. You actually have to go onto the Department of Consumer Protection's website and sign up and go and make sure that you're allowed to write prescriptions, DEA prescription, and have all of these checks and balances in there. You also have to be able to go into the prescription monitoring program. You have to have access to that in order to also write recommendations for medical cannabis. And they're making sure that all of those things are in place so you don't have a number of, pot docs coming in and just writing recommendations for patients. That's not the way this program is designed. This legislation is hands down probably the strictest regulations in the entire nation, and there's 21 states that have passed medical cannabis legislation, okay? They put that, all right, so patients and caregivers must meet strict requirements and act responsibly, so there's rules and regulations that garner that follow them. You can't use marijuana out in public. You can't use marijuana when you're around minors. And the producers and the dispensaries are going to be very tightly regulated and controlled. There's a whole bunch of checks and balances that I have to go through in that process as well. All kinds of background checks. The debilitating medical conditions, cancer, glaucoma, HIV or AIDS, Parkinson's disease, multiple sclerosis, damage to the nervous tissue of the spinal cord, and neurological indications and intractable spasticity, so shaking, epilepsy, cachexia, wasting syndrome, Crohn's disease, and post-traumatic stress disorder. So there's 12. They also have the ability to add more conditions, but that has to go through the physician board. You actually have to go before the board, argue your point, and the actual final word to that goes with the commissioner. Physicians are the gatekeepers, so the physician who certifies patients for medical marijuana must have a bona fide physician-patient relationship. And that's something that I adhere to and encourage all the time, because physicians really need to get an understanding of what medical cannabis can actually do. The physicians have to complete a medically reasonable assessment of the patient's medical history and medical condition. They need to diagnose the patient with having the debilitating medical condition, and then they also have to determine whether or not it is in the patient's best interest to prescribe prescription drugs as opposed to medical cannabis. And then they need to discuss the benefits and the detriments of the patient's use. And the physician also has to determine whether the patient needs a caregiver. So in other states, and I don't know how much, in other states, patients are allowed to have caregivers, and a caregiver is there to help that patient access cannabis. So, but you can only have, every caregiver can only have one patient. So in other states where a caregiver can have 5 patients, 3 patients, 6 patients. In here, in Connecticut, you can only have 1 caregiver to 1 patient. And really, so that's just if you're stuck at home and you can't get to a dispensary, then that's what the caregiver's for. Qualified patients must be an adult with a debilitating medical condition. So to qualify for medical cannabis, you have to be diagnosed by a physician, you have to be 18 years of age, you have to be a Connecticut resident, and you have to not be an inmate in the Department of Corrections institution or facility. Okay? So nobody from out of state can come to Connecticut and use our dispensaries. And not everyone can be a caregiver. So the caregiver model also, the physician has to certify that the patient needs a caregiver. The caregiver needs to be at least 18 years of age. The caregiver also has to have not been convicted of a law pertaining to the illegal manufacturing, sale, or distribution of a controlled substance. Where a patient lacks legal capacity, caregivers must be a parent, a guardian, or a legal custodian, and a caregiver can ordinarily be responsible for only one patient. The only exception with that is if it's in a family, and so a son can be the caregiver for his mother and his father. That's the only other.
Still has to be of age.
Yes. Patients and caregivers must act responsibly. They should possess no more than a 1-month supply of marijuana between both of them. No, they are not to use marijuana in a way that endangers the health or well-being of others, and they have to store marijuana in a secure location to prevent theft, loss, or access by unauthorized people. Marijuana cannot be used in a manner that puts others at risk. Marijuana use is prohibited in in buses, school buses, moving vehicles, workplaces, school grounds, any public or private school, dormitory, college, university property, public place, or in the presence of anyone under the age of 18. Patients will get medical marijuana through producers. Producers are the cultivators. In the state, there's only going to be no fewer than 3 and no more than 10 ever. That's in the statute. Okay, they came out asking for RFAs. They're initially going to only license 3 cultivators in the entire state. And in the cultivation center is where everything happens to the plant. So in the cultivation center, you're growing it, and you're packaging it, and you're also turning it into something that it's called an edible or a medible. So you're turning it into an extract. You can put it into a cookie or any kind of baked good or any kind of extract where you put it into a pill. Anything that is leaving the cultivation center is a packaged product, packaged and sealed product, okay? In the dispensary facility, they're run by a licensed pharmacist, and they're just there to dispense the product to the patient. And it's not a CVS, it's a standalone. And both the production facility and the dispensary facility both need to be licensed by the state.
And so all of the dispensed medical marijuana has to be produced in the state. Is that correct?
Yes. And that's everywhere. Producers will be limited and tightly regulated. Initially, the DCP expects to license only 3 producers. Statute does not permit more than 10. All cultivation and production must occur in a secure indoor facility. All cultivation and production will occur at locations within the state that have approved from the town in which they are located, and producers must have the experience and financial capacity necessary to build and operate a secure indoor production facility. Marijuana will be dispensed consistent with the statute as a controlled substance, and that's why the pharmacist is in the model here. That's one of the reasons why it's one of the strictest in the country, and that's also one of the pieces of it that I like the most. Having a pharmacist in this model it adds a layer of legitimacy to the fact that medical cannabis is actually a medicine, and it allows a really good dialogue to go between the pharmacist, who is the one who's dispensing this medicine, and the patient's actual physician. You don't really get that anywhere else. You don't really get that anywhere else in the country, and I'm really excited to see what that is going to look like here in Connecticut.
Does this dispensary allowed to sell anything else besides this?
No.
How do you expect this guy to make a living?
There's going to be quite a few patients. There's only, so you figure they're only going to license 5 dispensaries to begin with here in the state as well. Currently, there's approximately 1,000 patients and that's without having licensed dispensaries. And all the doctors that I know are actually waiting for the licenses to be awarded before they actually start writing recommendations, because they don't want their patients going out to the black market. They want their patients.
Prohibitively expensive, people are going to go to the black market. Why would they go to?
Because it's not going to be prohibitively expensive. It's going to be in line with what they would get in regards to in the prices of black market prices. But patients are already actually paying these prices.
I mean, pharmacists aren't cheap,
I know.
okay?
Licensed dispensary facilities will not exceed the number appropriate to meet patient needs. That's why they're only licensing 5 dispensaries to begin with. Currently, the DCP expects to license only 3 to 5 dispensary facilities. Dispensary facilities will be geographically dispersed. So they really looked at the state, and they're picking 5, and they're right around the outside. So, and we'll see. They're going to make sure that they are geographically accessible to the most amount of patients. But
I mean, Hartford, New Haven, and Bridgeport.
Stanford, Hartford. There's a small amount of patients that are in Litchfield County. They're not going to come out this way. They'll probably license a dispensary in Hartford. Probably somewhere looking around Danbury.
There's only 3 now.
Between 3 and 5.
Oh.
The cultivation centers really can be anywhere, because they're just going to be what I envision a cultivation center looking like is a little bit more like a pharmaceutical, like a small cap pharmaceutical company, because they're making medicine, and they'll be able to distribute it throughout the state. So it doesn't really. Marijuana will be dispensed by licensed pharmacists. Pharmacists are trained in proper handling of controlled substances, of course, and like I said, they're going to be able to have that dialogue with the physician. And pharmacists have experience counseling patients with regard to medical use and drug interactions. Communities are protected by strict regulations of marijuana businesses. Regulations and requests for applications require that dispensary facilities and production facilities be located and designed in a manner that will not negatively impact their local community, have tight internal controls and robust security to prevent loss, theft, or diversion, not advertise in a way that may encourage the use of marijuana recreationally or by those under 18, license or register all employees with DCP so that the department conduct appropriate background checks. They're asking for a lot of information for these people. These people will be significantly vetted by the time those licenses are actually awarded. Applicants seeking a production facility or dispensary facility license must provide evidence that state and local building, fire, and zoning requirements and other local ordinances are met. Text or other graphic materials that will be on the exterior of their proposed facility. Photographs of the surrounding neighborhoods and businesses sufficient for the DCP to evaluate the facility's compatibility with commercial and residential structures in the area and under construction. A map identifying places of worship and schools, among other things, that are within 1,000 feet of the proposed facility. Requirements for tight internal controls will limit access to marijuana. Marijuana must be stored in approved safes and vaults, only accessible to authorized employees. Only registered patients and caregivers may enter a dispensary facility. Except for emergency situations, only visitors approved by the department are permitted in production facilities or dispensary facilities, and marijuana products will be sold in child-resistant packaging. Alarm systems must meet strict requirements. Production facilities and dispensary facilities must have professional alarm systems installed that at a minimum include a perimeter alarm, motion detectors, video cameras in all areas containing marijuana and at all entry and exit points, duress, panic, and hold-up alarms, a failure notification system, and the ability to remain operational during a power outage. Advertising will be subdued. The exterior of a dispensary facility may not have more than one sign of a reasonable size. Use graphics related to marijuana or paraphernalia. Advertise marijuana brand names or have marijuana products or paraphernalia that are within the facility be visible from outside. Marijuana advertising cannot include a statement, design, or picture that encourages or represents non-medical or recreational use, portrays or is suggestive of use by anyone under 18, is obscene or indecent, or is false or misleading. Marijuana product names may not be identical or confusingly similar to the names of non-marijuana products or of unlawful products or substances, be obscene or indecent, encourage the use of marijuana for non-medical or recreational purposes, include words or phrases customarily associated with persons under the age of 18. All advertisement and product names will be submitted to the DCP to ensure compliance. RFAs issued on Friday, September 6th. Responses are due November 15th. The department expects to award licenses around the first of the year, which means production and dispensing facilities could be operational by spring. Licenses will be awarded on a competitive basis, with DCP giving careful consideration to the background of the applicant, its investors, and its key employees, the applicant's business and security plans, and the applicant's effort to be a positive addition to its community. And that is that. Do you have questions?
Why are you here?
Yeah.
So I am also interested in pursuing a cultivation license, not a dispensary license. And I have found a location in Simsbury. Can I say that? I did. I'm sorry. I'm an oncology nurse and a mom. So this is a first for me.
What size facility would you anticipate?
The facilities that I'm currently looking at are 40,000 square feet to 100,000 square feet. The reason okay, sorry. The reason the Connecticut bill is so good is because it has all the regulations in it. It truly is the strictest. And if you follow the rules and regulations that Connecticut has put forward, you're actually really making medicine for really sick people. Marijuana has a really long, crazy history. It was a medicine up until, it's always been a medicine, but it was in the U.S. pharmacopoeia up until the 1930s. And at that time, a lot of politics got involved in it, and it's been prohibited since then. And there was a lot of, and so when it got into the black market, like when marijuana became popular as what it is, as a party drug or whatever, however you want to say that, that euphoria part, the THC part, that got bred into the plant. Okay, it wasn't really THC. The euphoria part, the high part, was really not wasn't one of the most. Wasn't one of the largest components of it before that time. So marijuana or cannabis had been used as a medicine, ancient China, ancient India. You're talking about all these old cultures that used marijuana as this great medicine, and it helps with MS. It helps people eat. It helps people sleep. It helps people forget. It's amazing for PTSD, and it has a really good immunity product. It has really great works. It's an anti-infective, it's an antifungal, it's an antibacterial. The research on this has stopped because it was prohibitive. Okay, so they've been doing research on this in Israel, they've been doing research in Spain, in Italy, and they're finding some really amazing things that are coming out of it. So the part of when they bred more THC into this plant, there's over 80 cannabinoids in what make up what cannabis is. And so if anybody saw the CNN special from Sanjay Gupta called Weed, and you can Google that, it talks about another component to what marijuana is, and that's CBD. And CBD is a non-psychoactive, so it doesn't make you high, component to what cannabis does. And it has some of these really amazing medical properties to it. So what we want to do is we want to find strains and breed strains that are not high in THC to create these medicines and put them into, and make them look like anything else that you've ever seen. Like a capsule or a pill or a tincture. It doesn't have to be smoked. The way the regulations were written on this, you know, the recreational user of cannabis is not going to like what comes out of these dispensaries, because what's coming out of these dispensaries is really a medicinal product that has been lab tested. That's the other thing that I didn't see covered in here. All of this product is getting tested by a third-party lab, and it's getting tested for its active ingredients as well as any pesticides or heavy metals or any of those things. It's really being treated the way any other medicine would be treated, because the regs were written by a pharmacist. So what you're going to have coming out of Connecticut is some of the best medicine in the country.
So we appreciate all of this, and thank you very much. A lot of this information is available on the state's websites and the like.
Right.
It is getting late, and you haven't
That's
made a
fine.
formal application, and there'll be plenty of time to hear that. But just a couple of questions as it relates to interaction with the zoning commission, which is why you were here. If you had a 100,000 square foot facility, how many employees would be involved?
We anticipate starting off with between about 25 to 36 employees and ramping up to over 100 within 3 years.
Okay. And what's the capital investment besides the lease on the building that's necessary to build that kind of business? And I'm being specific about the
What was
tax
that
base,
question?
equipment that would need to be purchased and, yeah.
Right.
$6 million in
It's
leasehold
between-
improvements and equipment?
It's $4 million. It's $4 million because it's the $2 million escrow.
It's about $15 million.
Yeah.
Okay.
Yeah. Because you're talking about lights and plants, I mean, we're talking about lab equipment, we're talking about a research department, I mean, the gamut.
I understand. I'm looking at the business side of this, which
Mm-hmm.
is, you know, the tax base and the like, so.
But could you also tell us, I mean, you said you want to do it, but this organization that wants to do it, the entity, I mean, what kind of a net worth will they have?
Out of the gate?
Yes.
It's going to increase exponentially rapidly. I can't say out of the gate, I would say the net worth is
I don't know how to answer that question.
I'm sorry, I couldn't hear you.
Once you get a license, it jumps, I mean, based on the financials, to 20 million.
But they must have a net worth today if it's an organization.
Oh, you mean the backers?
I mean, right now, yeah, the entity.
I thought you meant the entity once licensed. I mean, what it consists of is a lot of different investors. So they have different financial profiles. So there's one.
I don't know if I
for example.
This would be a startup
Yes.
business that would take.
Exactly, it's not a business coming in from another state.
So
It
they're
can't be.
personal balance sheets.
Exactly, and the other issue and the reason why it's private investment is the banking is difficult. So it's a lot of private investors coming in with their own money, so one may be worth 100 million, one may be worth 10 million. Yeah.
And what we tried to do what we tried to do is instead of bringing people from the West Coast to the East Coast, we're trying to do it just with us on the East Coast. So we have Connecticut-based investors.
Okay, so we're not,
I have a question.
Okay.
Hopefully it won't take 10 minutes like the last one did, but, are you looking at existing properties in the area, or are you looking to build?
I'm looking at existing properties in the
Okay,
area.
so, I mean,
right, that's why I asked the leaseholding. All right. Well, thank you very much.
I appreciate it.
Yeah,
thanks.
we appreciate the opportunity to learn more about it.
You're not coming here because of our great tobacco growing soil then?
You know, I heard about it though while I was looking around.
All right, informal presentation by Fort Point, what is it? Next Point? East Point? East Point.
Tied up 3-3, Longoria homered.
Who did? 3-3?
Longoria hit a 3-run homer.
Killing me.
Sure. I am Brian Robick, principal of East LLC, based in Fairfield, Connecticut. Brian Robick, B-R-Y-A-N, Robick, R-O-B-I-K. From East Point LLC, based in Fairfield, Connecticut. So, I just wanted this is sort of informal, so I'll just sort of go through where we are. So this is going to represent an application for Lot B of the approved PAD at Dorset Crossing.
Right.
And it's, this is going to be 168 of the 216 approved units there, essentially. So just to give you a little brief about the site plan, and my site engineer will sort of go through it. I'll talk about the site plan a little bit, the buildings and the clubhouse and things like that. So it's 168 units in 7 24-unit buildings, essentially. This is if you come in off of the new road now. This will be our entrance here. We have this sort of clockwise circulation through the site. There's 24-unit buildings, 3-story buildings, which are, you know, what was been approved in the PAD, 40-foot average height. Roughly 50% one-bedroom to two-bedroom units. There are going to be a few studios. We're sort of working on that program. What we did here is, and Larry can talk about it more, is we're regrading the whole site, sort of sloping it down towards the detention area here. And what that does is sort of brings your sort of view corridor into the center here, because there's some on the site. There's this whole electrical thing that's on the other side. So we sort of slope the whole site down, if you will. You can see the topo lines there. So we have a clubhouse here in the entrance. We have we're going to put a dog park down here. This is sort of a centralized sort of maintenance area where they grow trash and all those things. We're trying to push that off to the side. Around the site we have 80 garages, which will be, you know, leased to some of the tenants. We're going to have some garages that are going to set aside for bike storage, and sort of we're going to have like a bike repair center, because I know there's a lot of biking in the area. And then on the detention area, we're going to try to aerate this pond to sort of make that a sort of water feature on the site. So that's just the site. As far as the clubhouse goes, this is an elevation of our clubhouse, which once again will, you know, be right here in the entrance. So it's going to be a 3,500 square foot clubhouse with a state-of-the-art fitness center, sort of a meeting room inside with an office for the leasing center. On the outside, there'll be a resort-style pool. We're going to have 3 or 4 barbecue areas with sort of like meeting areas and gathering areas. There'll be a large screen TV for sort of like outdoor recreation. And also on the site plan here, we're going to have like an outdoor fire pit as well. So we're trying to create sort of like a lot of sort of community spaces, if you will, for the residents. And then to our building really quickly. So this is just an example of one of the buildings, sort of 3-story architecture, like I said, 40 feet to the median of the roof. What we're trying to do is sort of use a combination of different materials. What we show here is a combination of thin stone, shingles, and clapboard. We try to sort of mix up variations, and depending on where they are on the site, we'll sort of mix up those finishes, if you will.
Are all the buildings identical?
They're identical in shape and size, but we're going to sort of vary the material.
Mix up the floor plans inside?
Yeah, make up the floor plans and size, and mix up the finishes on the outside, depending on where they are on the site plan. You know, whether it's in the entrance here, you know, maybe this one will have stone in some places, and this, you know, depending on where they are, try to sort of mix it up a little bit as you come through the site. And then just have an elevation of the garages. So this is a typical garage building you'll see here. We sort of broke up the roof there, just to change the architecture a little bit. So like for example, like these garages, because what we did to the site here, these will sort of be built into the slope, because the slope goes up here. And then when you come into the site, your line of sight, you won't be able to see really over to the other side where that whole transformer and stuff is.
You said about 80 covered garage.
80 covered garage, yeah. And from a parking point of view, the PAD had a 1.5 requirement. I think we're at 1.7. So we're pretty adequate.
Including the parking spaces.
Yeah, including the parking spaces. That's correct.
Where are the parking spaces that aren't part of the garage? On the street?
Yeah, they're not lined here, but it's all of this is parking. I think.
Pull in?
Yeah, it's all pull in. Yep.
Pull in parking.
Yep, it's all pull in parking. That's correct. Yep. So I don't know, Larry, if you want to just go through the site plan real quickly about the engineering stuff, if you could.
Good evening. For the record, Larry Edwards, professional engineer, offices in Easton, Connecticut. Yeah, basically what we've done is we've tried to take the site and lower the elevation, and the primary concern was the transformer station across the street. We were trying to get so that we tried to prevent or took the site away from these buildings so they weren't looking directly over to it. So between lowering the site and providing a nice buffered vegetation across the side, I think we're going to do a pretty good job of blocking that as being an image from these.
From the third floor?
What's that?
The third floor of these buildings?
Third floor, that's going to be touchy. But,
sorry, I didn't put that. We sort of did this section through to try to get a sense of, so we could ourselves, everyone get a sense of. So that's a building. These are the garages. Sort of. This is the slope we create. This is our planting, and this is the berm that the CLMP is doing with their plantings on top of it, basically. So we're trying.
Your answer right there, Ned.
Yep.
We did that. We did this exercise, to show ourselves that we were doing the right thing. And Tony Giorgio has been working closely with CLMP on sort of getting me to plant some bigger trees. So we were pushing them a little bit. Sorry.
Basically, engineering-wise, it's relatively straightforward. As was indicated, the traffic, it's two-way traffic around the loop. So during construction, this will be the primary entrance, and the phasing of construction will be clubhouse first, and then these two buildings, and then basically allowing these to be occupied, finish these, and allow construction operations to come in from this driveway, and then phase it so that we work our way out of the site, so that none of the tenants have to come across the construction site. They can access it through the lower driveway, and it seems to work pretty well in that respect. We've it's dual-sided parking all the way down, so it's driving on both sides. We've got, as I said, just over 290. This drawing doesn't have it, but it's just over 290 total parking spaces, which gives the ratio of 1.7 for the number of units. We've got handicapped, providing basically 2 handicaps per building, which far exceeds what is required for the total number of parking spaces. But that provides adequate access to each building.
Would be driveways or town streets?
These would be driveways. These are private, so the town would not accept any responsibility for them. Basically drainage, there's the existing detention water quality basin down here. As Brian had said, it does have water in it, so we're going to try to do something to get that aerated so that it can become a feature. But all of our storm drainage, there's a master drainage plan that was done as part of the conceptual design for the whole PAD site, and we have complied with that, and we're putting in-ground storm detention for all the roof runoff. That's part of what that plan had called for, so we've included that back into this site. And actually, the total coverage, where's my board? That's right here. Yep. But basically, the total coverage that we are proposing is actually considerably less than was originally proposed. The total coverage on the original conceptual drawing was just over 222,000 square feet. That's building and parking, and we're at about 194. So it actually is going to allow a little more green space and provide for less total impervious area on the site.
What's the density units per acre?
1.6, or 168 into 10, so is that 16.8 per acre?
Yeah.
It's getting late in the night for me to start doing that.
So how will that compare to the Gristmill?
I think in terms of, of course, they don't have quite as many buildings, but it's pretty similar, actually.
Similar, 16.8 per acre? I'm just trying to envision the density.
Yeah, I think we're a little bit further apart than their buildings, pretty similar.
And again, part of this whole concept for this PAD was there's this considerably large size.
A lot of open space.
Open space that was set aside for the whole concept area, so.
So just for me to put it visually in perspective, how many units per building?
24.
24.
Yeah, 24, yeah. Yep. Yeah, so you have basic, yeah.
And then basically it's set up with 2 entrances in each one, so there'd be 8 per full, 24,
Yep.
3, yeah. 8 per floor.
Can you show
4
me
per
the
side.
site again compared
Whole
to Hot
site.
Meadow Street?
The whole site,
Oh, you want the PAD? You want the PAD?
Yeah.
Yeah, I think it's yeah, so it's 10.3 acres, there you go.
Yeah.
Just for sake of comparison, the Ritson building, for example, is 24 units.
that's Lot C, right?
That's,
So this pond is going to be nowhere near the street.
No.
You won't be able to see any of this.
Yeah.
no.
How large are these units?
They range from 700 to 1,200 square feet, roughly.
And is there a target audience you want to attract to these buildings?
I would say our target audience is a lot of the employment over on Day Hill Road, because I think that we have a really good access to that. For this side of Simsbury, or that side of Simsbury, if you will, it's basically 5 miles if you basically go out that way. As you know, Amazon just announced they're going to be building a new building there. Yeah, they're building 1 million square feet, 1.5 million square feet.
Well, they pulled their application.
But they're going ahead though. Yeah, they'll develop.
All the jobs that went from Simsbury to Windsor, now the people are going to come live there.
Yeah. No, we think we have good access to a lot of employment, essentially.
Hiram, they still show the road, the make-believe road?
Oh, this make-believe.
Is that going ahead, or is
Well-
there any movement on that?
The part that is owned by Griffin Land, we don't know yet. But what has been constructed, you may want to just point that out, Larry.
Yeah, so this piece, it's been constructed to roughly right here, right now. That's done. In fact, that's going to be on the agenda.
Accepted.
Yeah, tomorrow night, I think it's on the agenda, in fact.
But there's been no movement as far as trying to do anything with the Griffin Land thing.
Yeah, no, 2 reasons. One is they haven't expressed any interest in doing anything with their property. And there really hasn't been any need because we still have good access to Hot Meadow through the existing road, through the Dorset Crossing Road, and then called the roundabout, and then the new road is called Castor Bridge Crossing, just so you know. But that'll ultimately, and I suspect that if Dorset Crossing comes back in with development on the final 2 parcels, the remainder of that road on their
We're
property.
fast approaching more lights in the north end of Simsbury than in Hartford. Okay? With the supermarket, the light by Hoskins, a light up here at this proposed intersection, which is already there.
There's already a light there.
Yeah. I mean, if we don't have that road going out, are we gonna end up with another light here with this amount?
It's already here, I believe, isn't it?
The light on the make-believe road is already there.
Yeah.
It's already
Straight across.
Oh, you're saying that, could there be one out here?
You can't drive on the make-believe road.
No. No, with a make-believe car you could, but, I don't know what the STC permit was for this. I don't know what the click-in was for, because I wasn't involved in that, so.
But that's a good question. We can check that before
Yeah.
you come back.
Yeah.
Take a look at that, sure.
So where do you stand with the design review board?
Yeah, let's,
We basically went preliminarily to them last month.
Yeah, it didn't seem like they understood the PAD,
Yeah.
to answer your question.
Because
They were questioning whether it was allowed to have this kind of density.
seriously.
Yes.
Yes.
And the size of the buildings, and that's
Oh,
what the
yeah,
focus was.
yes, they were talking about things that they were questioning whether you could put 3-story buildings, whether you could have that kind of density, and we had to point out to them that we're working in a box that's that was given to us.
Yeah.
And we're happy to conform to it, so it was a little unusual, I guess, if you will.
Okay, so this does not have a recommendation. Did they make a decision or not?
No, they did not. There was an informal there as well.
Informal.
And
Okay.
after that presentation, as it went out to the potential applicant, they're welcome to go back there. It's not required, but they certainly can go back there, or they can bring a formal application to the commission.
Okay. So,
They didn't have any further recommendations?
well, no, they weren't on.
They were questioning, we were not formal, we were informal, but they were
Right.
questioning the density.
Yeah, and that's really.
Yeah,
they
so
were
they
headed
should
in
be
the direction
speaking to
that-
the design of the building and the outsides and the appearance and those things. because-
Yeah, well, they
That's what I'm
they were even questioning the height. He was pointing out that the height, and, you know, the PAD, it says right on it, it's 40 feet the average
Yeah,
height.
it just seemed like the whole discussion went.
Sideways.
We
right.
talked 5 minutes about the buildings
And then
and
we
the
started-
appearance, and then we were back into the density, you know, how far the buildings were, should we have more buildings, should we have less buildings? And as a matter of fact, one part of it got to the point, why do we need this many units? Could we make less units? So that's kind of, it was becoming a planning meeting, not a design meeting.
Okay. So I think that we should encourage you to make the application. You need to make an application, right? Because we need to approve the site plan for this particular
Okay.
site within the PAD.
And should we go back to them, and do we need to go back? I mean, what's your recommendation? I'm happy to, but it just like it went, like I said, the discussion turned into a,
Well, so I guess this is the way this is supposed to work. The zoning commission recommends to the design review board that they review and work with you to be sure that they're comfortable with the building designs, fronts, appearances. That's their challenge.
Okay.
And I'll have Hiram direct them to do so, or the minutes of our meeting will reflect that we listened to your informal presentation, encourage you to proceed with your application. We would like to hear from Design Review Board on the appearance and design aspects of the buildings themselves. And whether you do that before or after you make, I'm encouraging you to make the application with concurrence, I hope, from everybody. I shouldn't speak for the commission, but that we will determine when you should go to the Design Review Board, and we will instruct them as to what the
Okay.
topic will be.
and it'll be the building.
The building itself, not questions of density or, I mean, it's all within the same Lot B that you talked about before. The density is virtually the same that you got approved under the PAD. The buildings are as described in the
Yeah.
PAD. So all of that should be presumed to be approved. Right.
That's what I presumed.
Okay. So it's really for the zoning commission to focus the design review board on questions of design and get a recommendation up or down from them. Even if they don't like the design, it can still come back to the zoning commission for our consideration.
Gotcha.
All right?
And would we do that and when would we do that? In 2 weeks? There's another meeting in 2 weeks?
You could submit it as soon as you like.
Okay.
The next meeting is in 2 weeks.
Okay. And then you guys will tell us, okay, we like it, but go back to design review and have them look at the building at that time.
Yeah, I guess I would ask, do we have minutes from that meeting for design review?
I suspect they are.
So I'm going to ask Hiram
Yeah, you
to
should go-
get results from that meeting and see where they really were on the design part of it,
You know,
and whether they,
it was too tall.
huh?
It was too tall and too dense, that's what they were. No, we did talk about the finishes a little bit, but then I would say it was probably 3 minutes, and then we moved on to
Yeah, and
density.
then just went in different directions.
So get me who was there and what, and we'll try to manage the
And
process.
I think we'll be happy to go back and discuss it and review it with them. We're not trying to get away from not doing it, but I think you understand, you know, we're kind of stuck between a spot there that we
Yeah, I think the
didn't
best
really
way
know where
to
to
do it
go.
would be to put an application in.
Yeah, we encourage-
Bring, you know, the formality of the process forward, then go to the.
Okay.
I think that's what we said we'd do. We don't want to have you have an endless loop back there.
Right.
Okay. Very good. Thank you very much.
I'm gonna go watch the hearing in Fairfield about medical marijuana, like it's on TV.
Same presentation?
It's not them though, it's someone else, it's been on the public, it's been televised down in my area.
Yeah, well, it's here. It's coming. I thought you were going to hurry home to watch the end of the Red Sox.
Well, I'm gonna click back and forth.
3 to 3.
What inning?
Bottom of the seventh. One out, one on.
Anything else when they go to the order, Hiram?
I'll just give you two things. This is a copy, this is a, I think I emailed everybody. There's a meeting in Hartford about new codes we've been working on, codes and cocktails. One item on the agenda.
I'm interested.
The more cocktails, the better the film.
Yeah.
For the cocktails and not the code.
The other thing I wanted to just mention to you was that the natural hazards plan that the CROG had sent, and I think we sent you along the executive summary that, if you would take a look at that, if you get, staff's position is we'd like to recommend that we would go forward with that, we endorse that. If you feel the same way, let me know the next day or so. I need to, before the end of the week, I need to let them know whether the commission endorses that or not, so.
It's not a lot of specifics in it. I read it.
What are we endorsing?
One of the
I read
things, yeah, one of the things that it talks about is encouraging municipalities to encourage LID incorporation into their regulations. The reason that that's important for us is we've done that study, we have the study, we have all that information, and I'd just like to say, as long as the commission's in favor of that, that's great, that's fine. So that helps us to sort of move that process forward, that's all. That encourages people that have large developments, for example, to use things like pervious pavement, to use things like rain gardens, to encourage them to use stormwater management techniques that are helpful. That's the kind of thing that will just sort of give us a leg up, saying to the developers, look, the commission's in favor of doing this, we'd like you to look at this possibility. That's really what it is, it's just a step to do that, that's all. So, that's all I really have for this evening, thank you for your patience.
Motion?
Adjourn.
Second. Good.
Who second?
Derek seconded.
Absolutely second, third, fourth.
Pick somebody.
Anybody. Hiram?